Mark Small's Civil Discourse now for August 18th, 2022. I was listening to the radio this afternoon and it said this device that is in the car and you turn it on and there are these waves that pass through the air and some of them hit an antenna a certain way. Anyways, on a local show, this guy was talking about death penalty cases and he's a lawyer and there's a death penalty case that's being filed in Madison County after the shooting of a police officer in Elwood. Elwood's in Madison County. And the individual on the show was talking about death penalty cases, and he's not death penalty certified. Now, he made a decent effort at discussing death penalty cases and how they're handled, but let me explain. I'm death penalty certified. I have been since 1995, I think. I mean, that whole time. And you have to get recertified every 2 years after an initial certification. I'd gone to capital defense training in Chicago. There's a 2-year refresher here in Indiana. And death penalty cases are covered by Criminal Rule 26. Rule 26 requires certain things of death penalty attorneys. Now, this goes back to the idea that a lot of death penalty cases get thrown out because people who handled them at the trial court or appellate levels weren't doing everything right. And so there are ineffective assistance of counsel claims. That's usually brought under Strickland versus Washington, but sometimes it's brought under Chronic versus United States. And it says that the lawyer, either trial or appellate or both, screwed up. But for the screw up, the outcome would not have been what it was. Now, death is different. The United States Supreme Court has clarified that over the years, and by the mid-1970s, several justices on the court thought that the death penalty would be found unconstitutional as inherently cruel and unusual punishment. I think Justice John Paul Stevens said he thought it was going to go that way. He voted to keep the death penalty kind of generally in some ways, and it was a 5-4 that said you have to change how you're doing these cases. And then we kept the death penalty in the United States. We are amongst such advanced countries as North Korea, Iran, Saudi, Russia, China. You get the picture. Most places don't have the death penalty. And there are several reasons, not the least of which is you don't kill people because killing's wrong. It also doesn't deter people from committing other offenses. And yeah, well, I killed that bastard. Well, yeah, but you're looking at the overall deterrent effect, and it doesn't have that effect. So what we've done is put requirements on death penalty cases. So if someone is charged with a capital offense and it's only a certain category of offenses, murder cases, then first thing is they get 2 lawyers. That's because there's so much to cover. There is a budget, and let me explain also, the 2-day recertification training for death penalty attorneys. It used to be the first day would be penalty or guilt phase. In other words, how do you put together the prosecution? The second day would be penalty phase. In other words, how to argue it shouldn't be death penalty. And the person on the radio today said, well, and attorneys for the defense probably start trying to talk about what can we do in terms of a plea. No. That's from the get-go. You're trying to avoid death for your client, because it used to be one day was guilt phase, the other day was penalty phase. Anymore, it's nearly all penalty, because it's trying to find ways to avoid the needle for your client. So it's not just, well, they kind of start bringing it up. No, the goal from the beginning is to make sure your client isn't executed. In Indiana, we have an alternative to execution. It's called life without parole, LWAP, and it is without parole. So if they're going to be convicted, they're not going to just frolic about eventually and get out of prison. It's life without parole. Now, there are reasons for this, one of which is that, like, not everybody is guilty that's convicted in a death penalty case. The Innocence Project about 20 years ago established in Illinois that about half the people on death row, that they were exonerated by DNA testing. And that's really a sad commentary on our system to have put that many innocent people on death row. But DNA is not dispositive of every case. It's not present in every case to use as a principal piece of evidence. So it's like, okay, was there some other means by which those other people could have been found to be innocent? Because see, once they're executed, they're dead. So if you give them life without parole, they're not dead and they can prove their innocence later. Another problem with the death penalty is it's disproportionately poor and non-white people. And people go, well, it's non-white people who commit most of the offenses. No, it's disproportionate. I would address that to racist idiots out there, because you've already got a disproportionate percentage of the population that's prosecuted for crimes. But even within those prosecutions, the criminal cases, it's disproportionately people who aren't white. So it's discriminatory. And then you get to the fact that they're nearly all poor. As Phil Oakes sang in a song, Iron Lady, a rich man has never died upon the chair. So you look at all those aspects, and the Supreme Court said death is different. So you're going into a case, you've got two lawyers, you have a bunch of funds that are available to them. Why? A lot of psychiatric testimony, because there are a lot of instances in which the person who was accused of the offense either is mentally ill or incompetent. In other words, their IQ is so low, they couldn't comprehend good from evil. They couldn't comprehend what was right and wrong. So you have testing of those people. You have people examining them. You have psychiatric reports. Those expenses start mounting up because the system wants to make sure that they're getting the right person, or rather, the person actually is being convicted consistent with the law so that that person could be executed. One county about 20 years ago ran heavily into debt when they tried to bring a death penalty case against somebody, and that kind of discouraged other counties from pursuing death penalty cases. So Indiana has not executed somebody, I think it's in over a decade. And now we have two cases, I think, that are capital cases that have been brought in courts. Now, the person who was talking about this today on the air was talking about different aspects of, like, well, it gets into a lot of money. It gets into a lot of money because they have to hire experts. Psychiatrists aren't cheap. Any type of person who's going to give testing, and that's psychologists generally do that, they're not cheap. There are only so many forensic psychologists, for example, in the state of Indiana. So you get all of those expenses. And then once the trial would be over, if the person is found guilty and sentenced to death, because that's a second phase of the trial, they have to prove beyond a reasonable doubt that the case qualifies as a death penalty case. So it goes up on appeal. One of the two lawyers that handled the trial case has to be one of the two lawyers that handles the appeal. Death penalty cases have a lot of transcript, a lot of records, a lot of things to go through. And lawyers who represent people who've been convicted and sentenced to death are on short time for briefing and filing those briefs with the Indiana Supreme Court. It doesn't go to the Indiana Court of Appeals. It goes straight to the Indiana Supreme Court. The next phase is to challenge the conviction through a petition for post-conviction relief. That's a collateral attack on the conviction and sentence. You're saying that something like ineffective assistance of trial counsel or appellate counsel resulted in the person being sentenced to death. And then The final phase is filing a petition for writ of habeas corpus with the U.S. District Court and taking that up to the United States Supreme Court eventually. You could also take the case up from the state Supreme Court to the United States Supreme Court, either on the direct appeal or on the PCR. That's why it takes years for someone who is convicted of a capital offense and sentenced to death to exhaust all the remedies that are available to them at law. And it should take that long because, one, we're supposed to be careful and make sure that the person who's being sentenced to death actually qualifies for that death sentence. But more than that, if killing is wrong, killing's wrong, whether it's by the state or an individual. So if we're going to have the death penalty, we have to realize that that really puts us in with a bunch of countries that are very backward. Countries that don't have the death penalty don't have high rates of murder, for example. And our society does have those high rates. I was talking to someone last evening at a political gathering, and I pointed out that they were talking about kids being shot in schools. And I said, well, the important element there is they were shot. And there are things we can take away that are going to reduce the number of deaths. The death penalty is not going to reduce the murder rate. It's been established. We should do away with it. Of course, Trump said of the Central Park Five, even after they were exonerated, not just that it was determined they weren't necessarily guilty. No, they were exonerated. They hadn't committed the rape in Central Park for which they were convicted. And Trump said he thought they should still be executed. He took out a full-page ad in the New York Times, to say still should have been executed. Why? I don't know. But that's the basic thing about the death penalty and how it functions, how it is carried out, and why people can sit there for decades on death row. Now, it's a lot less expensive to not murder in the name of the state. I'm Mark Small. This is Civil Discourse Now. Peace, love, happiness. Have a nice evening.